So we're looking at a case today that the Superior Court of Orange County actually described as Byzantine. And honestly, looking through the documents in Leona Horowitz v. Joseph G. Brown, that feels like a bit of an understatement.
It really is the perfect word for it, yeah. We're going to be focusing on this pivotal ruling from November 2022 by Judge Walter Schwarm.
And this isn't just some business dispute. It's the story of how an 81-year-old retired social worker spent, what, a decade?
A full decade, yes. Untangling this incredible web to expose what the court eventually called financial elder abuse on a massive scale.
The scale is what's so frightening here. You know, we're not talking about a stolen checkbook. You have Leona, the retiree, and she's trusting Joe Brown, her advisor, for 30 years. But instead of straightforward investments, the documents show he wove her savings into this incredibly dense network of shell companies.
Right. Entities with names like Brown Associates II, Pacific Medical Plaza. The mechanism here is, well, it's key. He didn't just take the money, he buried it.
How so?
He buried it under layers of limited liability companies. You see, in real estate law, this creates what's known as a corporate veil.
So it separates the person Brown from the assets.
Exactly. It makes it nearly impossible for an outsider, or even a partner like Leona, to see where the cash is actually going.
The Pacific Medical Plaza deal seems to be the smoking gun on that point. Brown's entities, they sell a lease for $5.2 million.
A huge win on paper.
Right. But the forensic accounting showed that Brown's own entities just siphoned off the proceeds. Something like $2.3 million in net profit just disappeared. It bypassed the partners completely.
It just evaporated into the Brown family network. But, you know, the abuse went beyond just skimming profits. The court records detail actual coercion.
The Bumblebee property situation.
That's the one. It's particularly disturbing.
Yeah, the tuna processing facility. The setup is wild. Joe Brown needs a $2.6 million loan for himself, but he needs someone else's collateral.
So he corners Leona.
He corners Leona. The court documents say she was, and I'm quoting, scared out of her mind. But he still pressured her into signing as a guarantor.
And that specific act, that pressure, is what tipped the scales legally. In California, elder abuse isn't just physical.
Right.
It's defined as the taking, secreting, or appropriating of property for wrongful use, forcing a terrified senior to back your personal loan. That fits the definition perfectly.
So Leona sues. She fights for 5 years. But just as she's making headway, the whole Byzantine nature of this thing bites back.
A third party comes in. Fidelity national title.
And they come in with this massive lawsuit against her.
It was a total mess. Fidelity hit her with a $4.4 million arbitration award. It's a classic war of attrition strategy.
Even if she wins against Brown, this other judgment could just swallow every penny she recovered.
It looked like checkmate.
But then we get to that November 2022 ruling from Judge Schwarm, and the court suddenly declares all these pending motions moot. Now, usually moot means irrelevant, but here it was actually the finish line.
It was moot because they finally untangled the knot. The parties reached a global settlement. They filed a document agreeing on a path forward.
And Leona filed a satisfaction of judgment in that Fidelity case.
Exactly. The controversy ceased to exist because the war was finally over.
But what's interesting, the court didn't just dismiss it and walk away. The settlement involved payments over time, so the judge had to keep the case technically open.
Just to make sure the checks actually cleared. Which brings up the biggest question I had reading all this.
How she could afford it.
Yes. Leona fought a wealthy, well-funded opponent for 10 years. How does a retired social worker afford the legal fees for that?
And that's where the elder abuse classification changes the entire game.
It really does. It triggers California's Welfare and Institutions Code, Section 15657.5.
The fee-shifting provision.
Uh-huh. Basically, if you can prove financial elder abuse, the defendant has to pay your legal bills. Without that law, an opponent like Brown could just bleed a plaintiff dry in court costs. It's the only thing that leveled the playing field.
It's a powerful safeguard. But it still required a decade of her life to enforce it.
And a judge who was willing to pierce those corporate veils. It proves that the complexity can be unraveled, but it takes an immense toll to get there.
It really leaves you with a heavy thought. If these complex structures are so effective at confusing ownership and, hiding assets, how many cases like Leona's never even make it this far?
How many victims just run out of time or money before the truth ever comes out?
That is the scary question. Thanks for listening to The Deep Dive. Stay curious.